And this case is before the court today on Plaintiff American Express. And in this case, I will note it is because it's important to the case, American Express National Bank versus David Menke, the plaintiff's motion for summary disposition under MCR 2.116C10. So I'd invite counsel to place your appearances on the record.
Thank you, Your Honor. Good morning, Jeff Werber, P67124 on behalf of the plaintiff.
Thank you.
Your Honor, Neil Riddell, P27423, appearing on behalf of David Menke.
All right, thank you, gentlemen. Mr. Werber, it is your motion, so I will have you lead off. And of course, the first issue here is, do we have the proper plaintiff? Is American Express National Bank the proper party when Mr. Menke, argues that his original was contract or agreement anyways was with American Express Federal Savings Bank?
That's correct, Your Honor. So historically, American Express operated its consumer banking and its credit card products under different banking charters.
I'm sorry, I want to object here. None of this is on the record. We're about to get testimony from an attorney in support of their position, and that's wholly improper.
This is a motion for summary disposition. I'm making an oral argument. It's in our
the argument has to be based upon evidence of record and what's in the motions and the answers and the affidavits. None of this, none of what you were saying was in an affidavit or is properly before the court.
Absolutely.
Sounds like you're testifying to facts that don't exist.
Okay, well, I'll overrule the objection at this time. I do recall there's a footnote in the affidavit that I reviewed anyways that indicates at least, an outline of the merger or acquisition or renaming of FSB to American Express National Bank. Ergo, I'll let Mr. Werber give some context to that. The objection's overruled. You may proceed, Mr. Werber.
Thank you, Your Honor. Exactly. That's all I was trying to do is place some context. So again, historically, American Express operated its consumer banking and credit card products under different banking charters. On April 1st, 2018, American Express consolidated these units into a single entity, American Express National Bank. That's it. And that is that's stated in the affidavit that was attached to plaintiff's motion. It's pretty clear. And defendant received monthly billing statements for years, for 11 years, never objected to any one billing statement, nothing. So my response to that issue is exactly that. Everything was consolidated April 1st, 2018. We have the proper plaintiff here. It's spelled out in the affidavit.
All right. Well, and I think that logically then brings me into the next argument, which is regarding this credit card member agreement, and that it is no one has produced to me anything with Mr. Menke's signature on it. So I'm going to go under the assumption that no such document signed by him, for whatever reason, exists for the purpose of this litigation, and that what your argument is that, well, Judge, the way these work is when you get the card member agreement, be it by mail or email transmission these days, it's there for you to read, and when you use the credit card, you agree to the terms, and they are what they are, and no signature required in effect.
That's exactly it, Your Honor. There is never any signatures on credit card agreements. The use of the card creates the agreement.
Okay, and just for my edification, though it's not really relevant here, I do recall instances, at least in the past, as a recent college graduate, these companies would send me a credit card. Hey, you can go ahead and use that thing. I assume if I had used it and paid bills and things like that, that I would have made myself subject to a card member agreement, even though I never signed an actual agreement.
Exactly, and I appreciate you using that real life example. You use the card, you agree to the terms of the card.
I don't get those offers anymore. My credit must be worse than it was when I was a college student, incredibly. So, okay, so you've got then, okay, we've got we've addressed the proper plaintiff issue and the issue of no signature required on the card member agreement, which then brings us to the question personal liability. I think I understand. I think his argument is, uh, at best he was a guarantor, and that a guarantee requires a signature. But I think the argument I read in yours is no, Judge. It's more than that. It's joint and several, straightforward liability. You sign up as an individual and as a corporation, um, and that's what we got here.
Yeah, a couple arguments on that point. Yep. When defendant received the card member agreement, it spelled out exactly that he would be jointly and severally liable. All the billing statements, as you can see, list David Menke first and then a business name after, which isn't even the proper business name. It lists American Trans RES, which isn't his business name. His business is a LLC. So it doesn't, I don't know how he can rely that it's his business should be the one responsible when it doesn't even list the proper business. But every monthly billing statement he received for 11 years had his name listed first and the business listed second. Never objected to that to any of the statements, like I said. Number two, if you look at these statements, and I know we attached a lot, but I'll just briefly go through some. The defendant was using this card for Delta airline tickets for his family. He was using the card for Polynesian pool and spa services, ski patrol, jewelry store in Colorado. This is all lately in 2024. Royal Caribbean Cruise Line on January 27, 2024. VRBO in January 10th of 2024. Again, Polynesian Pool and Spa Services, June 25th of 24. February 2nd, 2024, Delta airline tickets for 4 members of his family. So clearly, yes, there's a lot of charges that look like business charges on there. There's also a lot of charges that were personal on this credit card. And these aren't going back to 2011, 2012. This is 2024 that he's using this for a lot of personal travel, opening up what I'm assuming is a pool. I'm not sure it's probably at his home. So number one, card member agreement sent to him when he opened up the card, which clearly states he's jointly and severally liable. All the billing statements have his name listed first. The card has his name listed first. He's using the card for both business and pleasure. It's pretty clear that he would be personally liable. Like you said, Judge, when you were a college student, you would get these opportunities to open up credit cards without a signature. There are no business. There's no credit cards that are just in the name of a business. That doesn't exist because you know how easy it is to simply change the name of a business, go from an LLC to a corporation, change one name of the business. These credit card companies would be out of business if there was credit cards in just business names. That doesn't exist. The defendant is jointly and severally liable along with his business on his credit card. It seems very clear to me.
All right, very good. Well, I think I have had you respond to each of the arguments. I'll give you a chance to speak again, but let me hear from Mr. Rebuttal.
Yeah, Judge, first I just want to correct just a little fact statement that was made that's clearly wrong. Counsel talked about the name that appeared on the invoices, and he said, hey, it doesn't even name the company correctly, America's Transportation, RES. What the heck is that? That's not LLC. Well, what that is, Judge, when you look at them, is that there's not enough space provided to put the full name of the company. And the full name of the company is America's Transportation Resources, RES. And so
yeah, I took that away. I think his point more was, well, it's not the only name up there. It's also your client's name, Mr. Menke, and obviously this case is, you know, we're whatever America's transportation resources status is right now, they're not
Yeah,
the
and
ones
Judge,
on the hook for this. It's Mr. Menke, or allegedly on the hook, and that's what I got to decide today. So that being what it is, right? And of course, I guess it sort of doubles back though to. What where Mr. Werber left off, in that and I'll be the first to say I'm not a credit card expert. I can, barely maintain my one family credit card as is, but certainly I'm not familiar with credit cards coming out in the name of a corporation only. Typically, they do have a name, and in fact, my recollection of I'm old enough to remember the old American Express commercials where the guy would flash his card and say, "Oh, I've been a member since yada yada yada," and there would be a celebrity or whatever, making it very clear that American Express is in the business of issuing personal credit cards. They may do some business credit cards in addition, and this may be a business account, but nonetheless, it would make total sense to always to have a person attached to it. What's your argument as to why Mr. Menke would not be the person attached to this one?
I'll answer that in 1 second, Judge, but I want to jump back to the RES, and you noted that, but Mr. Menke's name appears there too.
Yep.
Anybody who runs a business will tell you that you get mail to your business that has your name and the name of your business. That's a common event. So I don't see that there's any significance to that. As to your question regarding Mr. Menke's alleged individual liability, you know, the statement that oh, no cards are issued just in the name of the company, that's a factual statement that appears nowhere. We haven't had a chance to litigate that issue, but I'll tell you what, if he'll take the call, let's call the chairman of GM or the president of GM and ask him if he's personally responsible for any credit arrangements made with GM through credit cards. And I bet the answer to that's no. I'm going to admit I'm not going to be as forceful as claims attorney and say this is absolutely something I know is true, but I'm willing to bet a couple bucks that that's true. There are such arrangements, and this, in Mr. Menke's experience and mine, was it. He entered into a credit arrangement for his company. Bills came to him on behalf of the company, and bills were paid until the company ran into some serious problems.
Well, and if I can just pause you, I mean, he's asking me to accept the idea that because, they've supplied a cardholder agreement that says the two of them are jointly and severally liable. Now, I get your client's argument that, hey, I don't have a copy of that credit, that cardholder agreement, but he's not presenting me with any counter cardholder agreement that, for example, would be between solely the company, that would say something different than the document I've been presented. Is it going to be your client's argument that he never signed and never had any agreement that's enforceable with American Express?
That's issue is addressed by Mr. Menke in his affidavit, and I think we need to back up. Well, one issue that hasn't been touched on by anybody at this point, and I raised it early on. They filed a written answer, didn't touch it. Is that this is, by the agreement upon which they're relying, subject to Utah law, and there's very specific provisions in the Utah statute, which I've cited and I argued, which apply to this situation. And the number one rule under that statute is that these credit agreements are unenforceable unless signed.
Well, but just to
exception.
pause you there, it has the same exact provision that I think Michigan would enforce, and what Mr. Werber's asking to do here, that says, well, but if you get a copy of it, even if you don't sign it, and then you go ahead and you use the credit card and don't file a written objection and say, I don't think you should charge me interest, or I didn't sign up for this credit card, et cetera, like your client does for 10 or 11 years, then it doesn't require a signature. So, I mean, in my view, Utah law is more or less a, in lockstep with Michigan law on that issue.
Yeah, the Utah specifically requires that if they're going to rely on the exception, they have to prove that the agreement was provided. And Mr. Menke has disputed that and has indicated that he has reviewed the corporate records. He indicated the manner in which the corporate records are maintained, that any agreements with creditors were placed in the creditor's file, and that they were maintained there and brought forward year after year. He's reviewed that file. No agreement is in that file. He said he does not recall ever seeing that agreement or having received that agreement. So he
Okay,
disputes
just
the
to pause
material
you,
fact.
I don't mean to interrupt, Mr. Riddell,
Yeah.
but to go back to his, his own affidavit here, he says in paragraph 7, well, I first established a credit relationship with an American Express company, of some sort, after ATR's formation as early as 2002, being my recollection. And then he does say he thinks it's with FSB and not National Bank, et cetera, et cetera. But you're asking me to accept the idea that there was never a governing agreement here, that he would have been, that i.e. American Express never sent him any kind of agreement.
With respect to Mr. Menke,
Well, or I mean, I think he's saying this on ATR's, because he's saying I reviewed the ATR records and I couldn't find one from them either.
there was no agreement whatsoever. Of course, ATR, America's Transportation Resources, is not a party to this case, so I haven't answered those arguments or allegations on behalf of America's Transportation Resources.
Well, and I'm not asking
like
for a substantive answer, but I think he's referring to ATR's record keeping, and that he says, okay, I keep these binders. If it's a bill, I put it in a separate, filing binder. But if it's an agreement, a contract, then that's going to, in effect, be carried forward to the next binder. So somewhere in there, arguably there should be, if he received the 2014 agreement relied upon by Mr. Werber in this case, it should be in there. And, arguably if he signed up for it in 2002, it should be in there, right?
if they sent one, it should be there, Judge. And I'm going to say that a material fact exists to whether ATR ever received a copy. And that's my point. Now, the statement was made that well, the bills were received month after month and no objection was made. Mr. Menke believed that there was a credit relationship between who he entered into the agreement with, American Express National Bank and America's Transportation Resources. So he would not have been surprised. He would not have objected to monthly invoices there. However, it's only at the end of the day where whoever American Express, the party in this case is, has popped in and said, oh, well, Mr. Menke is responsible too. When those first claims were made, we made the request of American Express to provide us the agreement. Nothing.
Okay. Well, here's what
they sent us a big wad of invoices.
Again, I understand your thing is a fact question, but I remember the jury instructions to say jurors, and obviously when I'm deciding a fact question here, I'm allowed to apply my own common sense and everyday experience as well. I don't have to necessarily defer to a jury. I mean, the standard for summary disposition is if no reasonable juror could find otherwise on this, giving you the benefit of the doubt. I mean, I've had a credit card for all of my adult life, and I can't tell you the number of times I received these similar to what's in here I'm looking at. This is this is American Express's exhibit with these billing statements. It's a massive exhibit. Let me see which one it is here. Exhibit number 3, and I'm towards the end of it here, I guess. It does have a Bates on the bottom. It's CMLENGDPRU S0328, and it's titled Important Notices, Changes to Your Card Member Agreement. And there it says, this one particular talks about penalty APR, but notably, on both this page, which is 5 of 7, and the next page, 6 of 7, it also reiterates we're adding the section joint and several liability in part 2 of the agreement to further explain the meaning of joint and several liability. And then it it goes on to the next page and defines joint and several liability as you agree jointly and severally to be bound by the terms of this agreement. That means both the basic card member and the company are each individually responsible for the account, including but not limited to the obligation to pay all charges. We may seek payment from either or both the basic card member and the company. And I guess my thing is here is when I receive my statements from my credit card company, it seems like almost every month there's some announcement of changes to my card member agreement that gets included with that. You're saying he didn't get any of those things?
He got no credit card agreement. He got no card member agreement.
No original card member agreement, and if he did get these changes attached to his bill, then well, and I mean, they say right there, if you want to review the whole agreement, you can log on and, or you can, I suppose there are probably other ways to get a copy of that whole agreement. But you're saying he never received the initial agreement. And if he did receive these things to changes, I guess then they're a nullity because there was no initial agreement.
He made payments pursuant to those invoices.
Yeah, I'll give you a chance, Mr. Werber.
Yeah, sorry
I
about
get
that.
your argument there.
He did not make
he's
payments,
going.
Judge. America's Transportation Resources made payments.
Yeah, I got it. Well, and I guess that goes to the second point that, I suspect most credit card companies are like this. They don't really care who the credit, the payment comes from. It's paying off as long as it's to them and it references the account and it pays off the account. And I also say this having litigated that unsuccessfully against a credit card company, that they ought to look at that. I know there's really no requirement that they look at who the payment comes from, rather that they accept the payment, it goes to the account and it pays it off. That doesn't really have any bearing on who the account holder is under the agreement. So I mean, I view who made the payment or who wrote the check as irrelevant to the discussion here. And of course, in joint and several liability, ATR could have done that for 25 years. But at the end of the day, if they don't do it someday, then they can still come looking to Mr. Menke, your client, and he's still on the hook, right?
Judge, I only made that point because counsel for the other side was being adamant that he made the payment. No, he didn't.
Yeah, well, I mean, I get it, but I mean, then again,
Okay.
Let's be real here. He's a sole member of an LLC making the payments. He pretty much knows what American Transportation Resources is doing too. This isn't like your Ford Motor Company example where, maybe that's a little more attenuated. I mean, I would expect him to be kind of aware of that. So, okay.
But it was it is an LLC, Judge, and it is separate and distinct from.
Yeah, I get it, but I mean,
Judge, I'd like to touch on a couple more issues if I may.
Yeah, you can continue.
Yeah, I wanted to back up to who owns this cause of action. Counsel for the plaintiff points to the footnote, and that footnote says these transactions were just a change in name. That's what the footnote says. Well, counsel's now provided somewhat more, and I say different explanation. What we really know is that whatever agreement existed with originally American Express Bank. That's where Menke first applied in 2002 for a credit arrangement on behalf of America's Transportation Resources.
We're assuming that's American Express FSB at that point.
I'm sorry, Judge.
That's FSB, Federal Savings Bank. That's the only other. Well, and then there's American Express Centurion, which, might be out there as well, but I don't think anyone's ever said, oh, I signed up with Centurion and they're my.
Well, Judge, I need to knit these together. The application was with American Express Bank. In 2018, American Express Bank transfers its assets to American Express Centurion Bank. And we've demonstrated that through providing copies of the records that are available to the public online. And those are included in David Menke's affidavit and addressed in paragraph 15 of his affidavit. American Express Centurion Bank still exists. We've demonstrated that too. in
But
paragraph.
your guy's not saying I signed up with Centurion, not National. Your guy's saying I signed up with FSB, right?
What I'm saying, Judge, is that the plaintiff in this case, American Express Bank, you get the right name, American Express National Bank, says they are the owner of the account. And what I'm saying is that, and they're saying that the reason for the name difference is because, and if you look at the affidavit of their purported keeper of records, there was a name change. And I'm saying, no, there wasn't a name change. There were conveyances of assets. The records show the asset went to American Express Centurion Bank. It still exists. There's no evidence in the record to show that the asset, which would be the account on which America's Transportation Resources exist, was transferred beyond that. So based on the record, and that's all we could deal with, Judge. We can't guess at what these people did. We can't. We know that they claim it was just a name change. We now know that that was wrong. That's not true. We know that that's the situation now. The last thing we see, this account is with American Express Centurion Bank. They are not here.
Well, or it could all be true, and that they transferred assets, and that they changed the name, and that on we go. And we all know corporations do change their names occasionally. It doesn't change the underlying agreements with the corporation. And I guess for that matter, even if it is an asset sale, I've given you all the benefit of your argument here, and it somehow flows through Centurion, but it winds up in NA. You know, I get the idea. Okay, I didn't sign up with you guys in the first place, but if they bought the asset, including the account payable, and your guy got invoices and didn't ever complain and say, 10 years now, I've been paying this, invoice, or my company's been paying this invoice without complaining about the name change or the change of agreement. How can you now come back and say, now you got the wrong, it's the wrong plaintiff?
Judge, my client didn't have to guess why it was that the invoices were in this other name. As a layperson, American Express looks like American Express, but when it comes time for litigation, when it comes time for proving facts, there are necessary and important distinctions to be made. And can any of us say here truly today that there is no dispute of fact as to whether American Express National Bank owns that account? I don't think anybody can, because the record, the facts upon which we have to deal, shows that the account went to American Express Centurion Bank. It doesn't show it going anywhere else. Yeah, there could be changes of name, and maybe they did that. Maybe, let's guess, maybe they did that. Well, that's not what we're here today to do, Judge, is to guess what they might have done with that account at that point in time. It's to put to the test where they are. This is their case. They had the opportunity to do a whole lot more than what they did. They used some form affidavit that they use in, I bet it's hundreds of situations. And it does not address the situation that exists in this case that we've raised. And I submit that there's no way for anybody to conclude that there's not a dispute as to a material fact on that question of ownership of the account. Now, another thing we have to do is we have to talk about Mr. Reban, who is the signer of their affidavit. He pretends to all sorts of knowledge. He starts out by saying that he's the custodian of records. Then he goes far beyond what would normally be associated with the role of a custodian of records, talking about what the practices and procedures are and how they apply. He never, ever demonstrates any connection between him and his employment and to what was done in 2002 or earlier than 2018 with respect to the practices and procedures. He doesn't indicate that he was involved in the company at that point in time. There's no basis for his knowledge. Anything he has to say is third-hand knowledge given to him. He has no direct personal knowledge. He did not mention or rely upon any written policies. It's just his bold and bald statement that this was the practice and procedure and that's how it was done. Well, there's no basis to conclude that he can provide that testimony. His testimony would be would not be permitted on.
Well, you haven't deposed him. I mean, there's no.
I'm sorry, Judge.
You haven't deposed him, so I don't have any counter statements or contradictory statements on the record from you to challenge directly the facts in the affidavit either. You're just saying its scope is far beyond that of a records custodian.
Well, I'll tell you what I did do, Judge, is that I did some written discovery.
Well, and is there?
And I want to get I will just get my thoughts together.
Yeah.
And I asked American Express, the plaintiff in this case, to identify documents or individuals that have direct and personal knowledge of those matters dating back to post 2000. That'd be the application and any agreements, and they objected and didn't answer.
And did you obtain an order or
No.
directing?
No, they objected and didn't answer. At that point in time, my philosophy is they made their bed. They've taken a position. They're not giving up that information. So,
okay. Well,
now,
I get it that there isn't, but I mean, at the end of the day, if it's an uncontradicted factual statement in the affidavit, unless there's a, and I get it, your guy submitted a counter affidavit, and I've got to weight that appropriately as well. But I mean, I really can't discount Ray-Ban's ability to say any of the things he does in his affidavit if I don't have evidence proving that he wasn't credible.
but Judge, his affidavit proves what I'm saying. He doesn't state that he was involved then. He doesn't state that he has direct and personal knowledge of what happened then. He doesn't state that he had.
Yeah, he doesn't reach back all the way to prior dates. He does somewhat limit his affidavit testimony to at least what happened during a certain time period. But I guess the question is, well, during that certain time period, he does say, I sent, I know American Express sent you these invoices. They also sent you the card member agreement. And when you're, kind of complying with that course of business and practice, and I really think, that's the strongest argument against you here is your guy got the benefit of the American Express card for all those years and never complained about it. And now, at the end of the day, he is coming back and nitpicking at details. How does that square in just an equitable sort of way?
Yeah, but Judge, I hear what you're saying. I hear what you're saying. But before he can get to the point where he says, and this happened and this happened, he has to demonstrate his qualifications to say those things. And he never does. Never does. We don't have any idea of the basis of knowledge because he doesn't assert it. And the peripheral facts that we know about him from the affidavit demonstrate that it wouldn't be based upon his involvement or his direct and personal knowledge because he wasn't there.
All right. Well, Mr. Werber, response on the foundation then, as it were, for the affidavit of Mr. Rebhan.
Yeah, I'll respond briefly to some of the points he brought up. You can see in paragraph 2 of the affidavits, this is I get these affidavits all the time from banks. This is beyond clear, this affidavit. The second paragraph says, in my capacity as assistant custodian of records for American Express, I am familiar with the ongoing credit card business operations and practices of American Express. That's what he's testifying. He's testifying that he reviewed the books and records of this account, and that's what he's declaring in the affidavit. Like you said, Judge, this is an account stated lawsuit. He's simply stating that that the defendant had this account. Defendant received the monthly invoices. There's no record of him ever objecting to these invoices, and this is what he owes. It's as simple as that. I think this affidavit is very clear and concise, and he simply is testifying that he's a custodian of records, and here's what the records say. I find it very interesting that opposing counsel skips over my argument on all these personal charges on the credit card. How do you get by charging month after month personal charges and then stating, oh, my business is liable for all this. Shouldn't have to pay for the pool services. I shouldn't have to pay for my gym membership. I shouldn't have to pay for my Delta airline tickets for my family. I shouldn't have to pay for the jewelry I charged in Colorado while I was on a trip. I shouldn't have to pay for ski patrol. I shouldn't have to pay for all these trips I took, all these VRBO charges on my credit card that I did all personally. My
Yeah, I think
business.
it goes really back to, I mean, I guess in the general rule of what's good for the goose is good for the gander. Well, just like who wrote the check and what the check said at the top probably isn't that relevant. Perhaps in the business context and the contractual context, and for that matter, the account stated context here, there is an equitable argument there, but really what he spent it on, well, we're not here to challenge, we're not trying to pierce the corporate veil here, I guess, because you don't have to pierce the corporate veil. You said he signed up for this personally in the first place. I think your point's taken, though, that, I mean, you can't say, well, I did all that as the president of ATR, and by the way, all those charges were for truck parts and driver expenses and yada, yada, yada. Some of the expenses could have bled over, there's possibility to use the credit card for personal expenses, and thus another reason to be aware that perhaps there was personal liability attached to the thing. So I think I understand the parameters of the argument. Well,
Your Honor, Your Honor, may I meant to address that, and
yeah, go ahead, Mr.
I
Rebuttal.
got sidetracked, and I thought maybe if I say something about it now while we're on the issue, it might be
Yeah.
This was never raised in the complaint or the motion, so that's why I didn't address it there. But had it been raised, what I would have been arguing, what I would have demonstrated is that, yeah, personal charges happen in situations where there's a corporate credit card, but there are accounting provisions that kicked in at that point in time, which when and if applied, create a situation where that's income for the person who makes the charge on a card of that nature. So just because there's a personal charge does not necessarily compel the reason that that the card itself existed for personal use. And as counsel noted, there were lots and lots and lots and lots and lots of charges that were business charges, and no effort's been made by counsel to provide, how much of the balance that they're seeking represents personal use versus corporate use.
All right. Well, I think I've got the parameters of the argument here to a point where I can rule at this point. And I will note this is a motion for summary disposition. It is brought before the court on both MCR 2.116C9 and 2.116C10. 9 being that there is no tenable argument that can be made that any factual development could support the other side's right in the case, and C10 being that no reasonable jury, even though there are facts here at issue, they are such that no reasonable juror could find on the basis of facts that would be admissible in court that the defenses raised hereto would prevail. And I am going to grant the motion on the basis of MCR 2.116 C10 for the following reasons. It is very clear that at some point Mr. Menke entered into an agreement with American Express companies. Originally, he may very likely have entered into an agreement with American Express FSB, and that is explained, at least in a very simplistic sense, in the affidavit of American Express, footnote 1, which is attached as exhibit number 1 to the plaintiff's motion, that says on April 1st, 2018, American Express Centurion Bank and American Express Bank FSB changed its name to American Express National Bank with a reference to a Office of the Comptroller of the Currency website there that appears to allow banks to change names like that without affecting the underlying obligations. And that, of course, is reinforced by some degree of common sense here, in that corporations do change their names, and for that matter, do participate in asset sales where they sell their assets to successor corporations. Those might include contracts and requirements to pay, and nonetheless, they continue to operate. Oftentimes, the goal being to make it as seamless as possible for the consumer of a credit. In this case, the company, American Transportation Resources, and Mr. Menke. And notably, these changes in the American Express name weren't held secret, or it wasn't a sneaky way of changing the underlying agreement with Mr. Menke, but rather they were reflected in the invoices that were submitted to Mr. Menke on a monthly basis. In that, they indicated that they were, they're from all from American Express here. Sometimes American Express Business Gold Rewards, referred to as American Express, with their address that the bill sent to in the City of Industry, and also has American Express listed there, the different locations that one can turn to for customer service. So the certainty is this was all American Express. Mr. Menke himself attached to his affidavit a copy of his American Express card, which almost everyone knows what it looks like because they've advertised effectively, at least they used to, on television about the American Express card. And Mr. Menke did enjoy the privilege of being a card holder for many years, and understood that his agreement for credit was with American Express. And I'm going to hold, for purposes of the record today, there is a question of fact, but it's not a material fact as to whether that was the FSB or whether that was the National Bank Association. The key is, did the terms of the card member agreement change when the name changed or the corporation changed? Was there a material change to the terms of the agreement? And it doesn't appear in this case, because American Express is relying upon a 2014 card member agreement, that those terms did change in conjunction with the name change. It was simply a continuation of business as usual, and notably a continuation of business as usual on the recipient's end by Mr. Menke and his corporation, who had the card. Secondarily, the question then becomes, well, how can this card member agreement be enforced against Mr. Menke himself individually when he never signed a document? And the answer is straightforward there, both in Michigan and in Utah. Both say that when a copy of the agreement is provided to the recipient, the beneficiary here, the other party, and the other party utilizes the credit card under that agreement, then the individual is bound by the terms of the agreement. Now, Mr. Menke argues, well, you know what, Judge, I reviewed, what looked to be, his personal records, I assume, and also ATR's records, and I didn't find any credit card agreement. Not a 2002 one, not a 2014, none. Well, it beggars common sense and general knowledge that no credit card is going to extend you the benefit of utilizing that card without holding you to some sort of card member agreement. And Mr. Menke, as a business person, would have known that there would have been some sort of agreement underlying his utilization of the card. I know that as a credit card holder. Every juror that might be summoned into service in Kent County that owns a credit card will also know that these aren't extended to us through the goodwill of the credit card companies and their wish for us to have a enjoyable lifestyle, but rather we utilize that credit pursuant to a card member agreement. There's no question here that any reasonable juror could find any other way, that there must have been some agreement. Now, what agreement was it? Well, the only agreement I've been provided is a copy of an agreement that apparently dates from 2014, and that is attached to plaintiff's motion here. As Exhibit 2. And it starts out as of 5/13/2014. So that's where we get the name, company name. That is the company it's provided to is America's Transres. I don't think it takes too much to leap into that was in fact Mr. Menke's LLC, America's Transportation Resources, and importantly here, card member name David Menke for the account, states some information about the interest rates, etc. Importantly, when you move into the card member agreement, this is, boy, it is again part of that same exhibit, which I think I just said was 2. I'm looking specifically at a document labeled Card Member Agreement Part 2 of 2. Words we use in this agreement. Part 1, basic card member means the person who applied for this account or to whom we address billing standards. Billing standards presumably being bills. Company means the business for which the account is established. You and your mean the basic card member and the company. You agree jointly and severally to be bound by the terms of this agreement. And then later on that page here, which is, I've got, several doc numbers at the top. It says on the right-hand side of it, next to Part 2 of 2, Doc 27310, promise to pay, you promise to pay all charges, obviously addressed to both here the card member and the corporation named on the bill. Now, if we move then to the bills that were submitted to the company and to Mr. Menke individually, these are attached as Exhibit 3. They're voluminous, multiple pages. However, they are clearly addressed to him individually, triggering the term you in the alleged agreement, and also the company, making it clear that those are the two individuals jointly and severally liable for payments on there. I find today, as a matter of law, it doesn't matter who made the payments, whether it was American Transportation Resources for 20 years. It doesn't impact the issue of joint and several liability. When they stop making the payments, both individuals on the account are jointly and severally liable for any amount that's still remaining. And that, of course, is the name of joint and several liability. It is distinct, of course, from a guarantee, a personal guarantee, or another way that a person might answer for a debt of another organization. It is simply straightforward liability, in that it is both parties are equal and fully liable for the entirety of the amount. There's not a half and half division or anything of that nature. That is, of course, the legal definition of joint and several liability here in the state of Michigan and every other state that the court's aware of. And that's reiterated. And I'm going here in a billing statement. This is, towards the end of that voluminous stack of billing statements. And I think I referred to this previously. Thought it had a Bates number on it, but perhaps I am incorrect about that. Well, it's after what I thought was a Bates number. That's actually just a, looks like just maybe a notation on the bottom of a bill. In any case, this document here, let me see if I can put just a rough parameter around it so it could be identified by a reviewing court here. This starts on, it's titled page 1 of 7. It is dated payment due date July the 7th of 2025. Shortly before this became an issue and the matter went to litigation, and it is labeled page 1 of 7. And if I flip there to page 6 of 7, there is a redefinition or a definition. We're adding the following section, joint and several liability, to Part 2 of the agreement. Joint and several liability, you agree jointly and severally to be bound by the terms of this agreement. This means that both the basic card member and the company are each individually responsible for the account, including but not limited to the obligation to pay all charges. And we may seek payment from either or both the basic card member and the company, precisely what American Express is doing in this case. Point being that the idea of joint and several liability was stated in the original card member agreement that's been presented to the court and then reiterated in detail of changes to card member agreements, and at least one billing statement received subsequent. And the court will note here it's applying, again, it's common sense and general knowledge that when the credit card company sends me electronic invoices and paper invoices, they frequently include changes to the card member agreement. With that, every credit card holder knows that first of all, they're going to include those, and second, that you ignore them at your peril, because of course they're going to bind you. And secondly, if you really want to read that whole agreement, that you can contact the credit card company either online or by calling them or whatever, and obtain a full copy of the agreement to which you're bound. So the reference there implies that as Mr. Menke, as the owner of American Transportation Resources, receives and pays the bills for that company, he is in effect put on notice that he's doing so pursuant to a cardholder agreement. There's no mystery here, no fact for a jury to determine. This one is so beyond cavil that there just simply wouldn't be an argument that a reasonable juror could find in the other direction. So bottom line is then by virtue of that and receipt of bills for some 10 years and utilization of that card and the extension of credit, receipt of, if you will, the benefit of the credit, he agreed to the terms of the card member agreement. They were stated and restated to him, and that's simply what American Express is attempting to enforce today as they bring it against Mr. Menke individually pursuant to his joint and several liability. So for all those reasons, the plaintiff's motion is granted, and I will request Mr. Werber to submit an order reflecting that.
Your Honor, we did submit an order with our motion and brief. I don't know if you have it. It's after the brief and right before the proof of service. If that works for you. If not, I can certainly submit a new order.
Why don't you email a new one to Lisa with, of course, a copy to Mr. Riddell, and I'll review it if Mr. Riddell wants to object. Otherwise, I'll sign it pursuant to the 7-day rule.
Okay. Thanks, Your Honor.
Very
Thank you,
good.
Judge.
Thank you, gentlemen.
Take care.
Take care.